Hi, today we're here with Rajvir Sidhu of Fleetwood Notary. We're going to be discussing title registration and the different types of ways you can register your title with a co-owner. I've had quite a few questions from people about how the lender prefers you to register your title. In most situations, the lender is not concerned with how you register your title. There are two different ways, joint tenants and tenants in common, that title registration can be done. Rajvir, can you explain what joint tenant registration is?
If you are registered as joint tenant, both parties have equal interest in the property and right of survivorship applies.
Okay, then how about tenants in common?
If you are registered as tenants in common, you can have equal share or you can have unequal share. So 50-50 or 70-30, and right of survivorship doesn't apply.
Okay, so the biggest takeaway is joint tenants is 50-50. If something were to happen to one owner of the property, the person remaining on title gets their share. Is that correct?
Correct.
However, tenants in common, if something were to happen to one of the owners in the property, that owner's share is now going to go to whoever they have listed in their will and to their estate.
Correct.
Yes? Could you give us maybe an example of joint tenants and tenants in common that you see most commonly?
If you're purchasing a property with your spouse, you want to be registered as joint tenants. But if you're purchasing a property with a friend or a relative, you want to be registered as tenants in common.
Okay, great. Ladies and gentlemen, make sure you ask these questions when you're signing at the lawyer or notary. Should you have any questions in the meantime, Rajvir would be more than happy to help answer any questions and help guide you through the process. Thanks for tuning in, and we'll see you next time.